Good morning. Are
Good
you Crystal
morning.
Latulis?
Yes, Your Honor.
And Ms. Latulis was previously in court, entered pleas of guilty in cause numbers 25 DCCR 0850 and 0851. I've received that pre-sentence report. Has everyone had an opportunity to review it?
Yes, Your Honor. Yes, Your Honor, we have.
Any additions or corrections?
No, Your Honor, not from the state judge.
And so what is the status? Is Child Protective Service still involved or have they closed
Your
out their
Honor.
case?
They closed it.
And where are the children?
I have four of them with me and one of them with my grandmother, Your Honor.
And that is what the plan was with CPS?
Yes, ma'am. Yes, Your Honor.
So Kylan, the one that had to do with this offense is with the grandmother.
Yes, Your Honor.
What is the plan with regard to him? I'm sorry, is it a boy or?
It's a boy.
Is the plan for him to stay there? Or are you wanting to have him back?
Yes, ma'am. I want to have him back, Your Honor.
Gilbert? Gilbert? Mr. Nichols,
Yes, Your
what
Honor.
are your thoughts on with regard to?
All my indications are CPS closed the case out and that she's done everything they'd asked her to. Looking at the facts of this case, it seems like it was a one time. And I think CPS hasn't really weighed in against
Right.
this to get the child back. So
Oh,
if she's doing the steps she needs to, then that's probably what's in the child's best interest.
thank you. And did you already do a parenting class?
Yes, Your Honor.
One of the recommendations is for you to complete a parenting course offered by Faith Tabernacle
I
Church.
did.
You already did
I did,
that.
Your Honor. Yes, ma'am.
Okay. All right, then I'm going to find in each of your cases, Ms. Latulis, that you previously entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, in cause number 25 DCCR 0850, I'm going to follow the agreement, defer all proceedings to place you on probation for 5 years. You're ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation.
Yes, ma'am.
And cause number 25 DCCR 0851 also find sufficient evidence to find you guilty. I'm going to follow the agreement in that case also and
Yes,
defer all proceedings, place you on probation for 5 years.
Yes, ma'am.
You're ordered to pay the $500 fine in that case and to follow all of the rules and conditions of probation. It sounds like you're already well on your way to doing what you need to be doing. I'm not at this time going to order the no contact. It looks like you've already followed through with the parenting class and everything you needed to with CPS.
Yes, ma'am.
Obviously, especially this child needs special care.
Yes, ma'am.
And so, you know that
Yes.
as well as anybody.
Yes, I do, Your Honor.
If you do everything that you're supposed to on this probation, then
Mhm.
this is a great opportunity because you don't have felony convictions on your record. And if you successfully complete the
Mhm.
probations at the end, your cases will be dismissed. You'll never be a convicted
Mhm.
felon.
Thank you, Your Honor.
The other side of that, though, is if you violate any condition of the probation, don't follow any of the rules, you could be brought back into court. You could be found guilty in each of the cases, and you could go to prison for anywhere between 2 and up to 20 years. You understand?
Yes, Your Honor.
All right, I'm handing you the trial court certification that shows these were agreements that I followed, and so you waived your right to appeal.
Yes, I
You
did.
need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork.
Yes, Your Honor.
Good luck.
Good
to you.
day.
Yes, ma'am.
Thank you, Your Honor.
Ernest Sinet.
He was there. Well, he's here. He just because of the election.
Good morning, you're Ernest Sinet.
Yeah.
I don't. In Ernest Sinet's case, I don't see the motion in here.
Like it was filed on September 7th. You need mine?
What can we just say? It's also all out of, usually this is in date order when I look at documents. So maybe it's someone's name. County. And during the date to send in. You want to print it? Nope, I found it. That's what I needed. Okay. It just changed stuff that
Because it's a new computer, it would be saying on the previous set.
I don't know what I just did here either. Sorry, give us just a minute. New computers. So I did the add a new document version, but it just did this. It usually says prior version underneath it, so I don't want to mess up. It's like that. May I try? Yeah. Where are the other? Let's try it again. Right.
Doesn't on hers. Communication of everything that he's going to.
Send it to you, then. I think that's just a pain. Yes, thank you. So I can get one if you need it.
No, ma'am.
Huh? Where is it? This is your motion to revoke. I was telling you that earlier. They say you found it.
Yep.
You have it here. Now it's here. True or not
That's
true?
good.
You're gonna ask how you plead. Then you'll,
Mr. Sinet, the best you can, would you please raise your right hand? Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you, sir. You put your hand down. And will your client waive the formal reading of the motion?
Hey, well, Your Honor.
Mr. Sinet, in cause number 21-37107, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation February 17th of 2025 for the offense of indecency with a child by sexual contact. And that was a 10-year deferred probation. Is that correct?
Oh, yes.
Okay, this motion alleges that you violated your probation. Count one alleges that you failed to successfully complete an approved sex offender treatment program with a licensed sex offender treatment provider. And is that true or not true?
Not true.
Count two alleges that you failed to submit to a polygraph examination or other evaluative examinations on May 17th of 2025 at the direction of probation. Is that true or not true?
Not true.
All right, so I'll have pleas of not true entered for counts 1 and 2. What we'll do is reset this for a hearing. I would assume it wouldn't take too much time, just the probation officer probably. Yes. All right, so we'll reset this for a hearing on sentencing. Obviously, if there's anything that's important for me to know, make sure you get that information to Mr. Parker. As this is an open plea, and I'll determine if those things are true, and if they are true, what if any sentence should be imposed at that time. Okay. All right, we'll see you back at the next court date. If you'll step in front of the clerk over here, she needs your finger.
Good morning.
Good morning. Are you Kristen Bell?
Yes, ma'am.
And Ms. Bell, this is your initial appearance in cause number 25 DCCR 1812. You are charged with injury to a child, elderly, or disabled individual. It's a state jail felony from October 6th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. Whenever I spoke to the judge, I told him I would do a court appointed.
Right. So when you're in custody, we automatically would give you a court appointed lawyer. Since you've made bond, I expect you to try to hire a lawyer. So what I'm going to do is reset your case about 30 days or so to give you some time to see if you can get someone hired.
Okay.
If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail.
Okay.
Okay. Step in front of the clerk right here. She's going to give you your reset notice.
Thank you.
Yes, ma'am. Good morning. You're Carrie Gilbo?
Yes, ma'am.
And Ms. Gilbo, did you get someone hired?
Yes, ma'am. No, ma'am. I can't afford any lawyers, but I have tried. I called like more than 3. And they all told me they're
prices and I still can't afford them.
Who'd you
But I
talk to?
have, talked to,
You can just tell me the name.
I talked to, James, I think, wife, Kimber, and, Ryan Gertz.
Okay. And how old are you? You're not in school?
No, ma'am.
Okay. Are you working?
No, ma'am.
Aren't you working?
I actually have a job. I'm back at home in Houston, but I had to come out here so I can, figure this out.
Okay, so thank you for doing what I asked you to do. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer.
Yes, ma'am.
You need to fill it out accurately and completely. Don't leave zeros on everything. Just write whatever bills you have, whatever, any income you might have, and then I'll take a look at it. You're gonna swear under oath that it's all true and correct.
Okay.
Step in front of the clerk. She'll give you that paperwork. Morning.
Good morning.
Are you Alyssa Bush?
Yes, ma'am.
And Ms. Bush, this is your initial appearance and cause number 25 DCCR 1754. You're charged with the state jail felony offense of credit or debit card abuse, and that's from September 6th of 2025.
Yes, ma'am.
And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
We couldn't afford it. Our bail's bondsman said that today would be the day to fill out the paperwork for an appointed attorney.
How old are you, Ms. Bush?
I'm 17.
17. Are you still in school?
Yes, ma'am.
Where do you go to school?
Nederland High School.
Okay, so I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
Step in front of the clerk and she'll give you those instructions. Good morning.
Good
Is it
morning.
George or Jorge?
Both.
Okay, and did you get someone hired?
Yes, I got right film, but I stole them like 123 left.
Okay, you brought a receipt?
Yes.
Good. So when will you be able to get him, you think,
Uh,
the next couple weeks, 3
Couple
weeks?
weeks.
Okay, so we're just gonna do one more reset,
Yes,
to
ma'am.
give you some time to get him paid off, okay?
Okay.
Make sure you bring that reset notice to his office and they'll tell
Yes.
you what to do.
All right. Thank
You'll
you.
step in front of the clerk, please. That was missing a TRN, but it didn't make the big loud sound, which makes me wonder if my sound is on. Good morning. Are you Patrick Brooks?
Yes, ma'am.
And Mr. Brooks, this is your initial appearance in cause number 25 DCCR 1652. You're charged with the state jail felony offense of fraudulent use or possession of identifying information, and that's from October 8th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, actually, I was never booked in through Jefferson County or anything like that. I actually got picked up January 1st of this year, stating that I had these warrants. And then I had to bond out. I had to spend $2,000 to get out after speaking to investigator Reggie Boykin and the sheriff's office right here. I talked to Miss Brooke. They found out that it was another guy named Scott Anthony Doss using my name. I had to go do an identity report and stuff like that. Like, here's some dates where it's like, I heard he got picked up October 9th as well for something. Then also in Orange
Hang on.
County.
So hang on just a second. That's all information that probably the district attorney needs,
Yeah.
not me. So, is Mr. Coleman gonna be here? Okay. When have a seat. When Mr. Coleman gets here, would you have him take a look at this? I'm gonna have Mr. Brooks have a seat. Sounds like there's some information.
If it's an identity theft, I think he needs to go up and tell the front desk and our civil division should handle it.
I did a identity
Things
report.
have to be done.
He's already done some of that, sounds like, and I mean,
But he hasn't talked to us.
They talked with them.
yeah.
Okay.
Yeah, when Mr. Coleman gets here, would you just have him just have a seat when when the assistant district attorney that's assigned to your case gets here, here in the courtroom. Good morning, you're Deanna Paul.
Yes, ma'am.
And Ms. Paul, this is your initial appearance in cause number 25 DCCR 1792. You're charged with the third-degree felony offense of stalking, and that's from October 3rd of 2020. Stand up. What's the matter?
Nothing. My allergies.
Okay. If I test you this morning, you gonna have anything in your system?
No, ma'am, but I just sneezed back there.
Okay, let's double check it. Have a seat in the jury box, please. Good morning, your Miracle Oville.
Yes, ma'am.
And Ms. Oville, this is your initial appearance in cause number 25 DCCR 1779. You're charged with the third-degree felony offense of tampering or fabricating with physical evidence, and that's from August 31st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I have not.
Okay, so what I'm gonna do, Ms. Seville, is reset your case for about 30 days or so to give you some time to try to hire a lawyer.
Can we do maybe 60 to 90 days?
I do 30 on all of them. And so here's the thing, if you can't hire someone in the next 30 days, I want you to at least try. If you make a down payment to someone, bring me a receipt. If you're unable to hire someone in 30 days, then I'm just gonna order you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me the names of the lawyers you've talked to when you come back, and then we'll discuss your options if you need more time and things like that. But we're gonna do every 30 days until we get it figured out, okay? So if you get someone hired, bring the reset notice that you get today to that lawyer and they'll tell you what to do. Again, if you're not able to hire someone, make sure you speak to at least 3, bring me those names. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order I just gave you, and you would have to go back to jail. Do you understand?
Yes, ma'am. Can I just say that I was under the impression that when I spoke to my bail bonds, that was a court-appointed attorney.
So when you're in custody, you automatically would give you a court-appointed attorney.
Mhm.
But once you make a bond, then I expect you to at least try to hire your own.
Okay.
So go through, follow those rules, try to hire someone now that you've made bond, and just do everything I asked you to do. Again, if you get somebody hired, bring the reset notice to them. If you can't, visit with at least 3 and bring me those names.
Okay. One last question. Does the attorney have to be out of Beaumont?
No, they can be wherever as long as they practice here.
Okay.
Just make sure that whoever you're talking to, if it's out of town, make sure they know that the case is in Beaumont.
Okay.
Sometimes if it's out of town, they might charge a little more because they have to come here. They may say, I don't travel to Beaumont. I'm not sure. Where are you from?
I'm coming from Richmond, Texas.
From Richmond?
Yeah.
Yeah, there's definitely Houston attorneys that come here. It might be more reasonable to talk to some here, but I'll leave that up to you. You can visit with whoever you want to. Okay, you'll step in front of the clerk. She'll give you a reset notice.
Morning.
Good morning, you're James. Is it McEwen?
Thank you.
And Mr. McEwen, this is your initial appearance in cause number 25 DCCR 1186. You're charged with the state jail felony offense of theft of property from December 5th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I have talked to several.
Okay.
I haven't got anybody hired yet.
All right. So what I'll do, Mr. McEwen, is reset your case for about 30 days to give you some time to try to get someone hired.
Yeah.
If you do get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 attorneys. Bring me back the names of the attorneys that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you that reset notice. Good morning. Good morning, sir.
Good morning, sorry.
What is your
My
name?
name is Diego Armando Aguilar.
What's your last name?
Aguilar.
Aguilar.
Yes.
Mr. Aguilar, would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? So help you God.
Yes, Your Honor.
Thank you. Sir, are you Juan Martinez Rodriguez?
Yes.
And so, Mr. Macon, it looks like you've been on since October. I will reset it one more time. This will be the last reset. Make sure, if you'll let Mr. Martinez Rodriguez know that he needs to make an appointment, visit with Mr. Macon before that next court date.
Yes, ma'am.
Anything?
Okay.
Okay.
30 días, necesito hacer una cita con él para la
I'm sorry.
próxima.
Thank you. Y'all are free to go. Thank you, sir.
Call my office.
Mr. Parker, you've got Brian Belvin.
We've reassigned a lot of those just
It's-
for the next couple of weeks. So Ashley has that file.
It's hers, but she.
Yeah.
I talked.
But is she gonna know today is my question.
I don't know. I mean,
Okay,
I would.
is Ms. Malfino on her way?
She is.
Okay, we'll hold it until she gets here.
There was a bad wreck on I-10.
Yeah,
She said slow road.
yeah, Ms. Warner had to. All right, ma'am, is it Isis?
Yes, ma'am.
Traddles? And Ms. Traddles was previously in court and entered a plea of guilty to the state jail felony offense of injury to a child in cause number 25 DCCR 1478. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Have Your Honor.
State has, Judge.
Are there any additions or corrections?
Nothing, Mr. Spencer.
Judge, I would like to address the statement made by the victim's mother, Heather Powell, on page one of the PSI where she claims that the district attorney's office has not returned her phone calls or emails. For the record, I have not received any phone messages or emails from Ms. Powell. I did, however, my file reflects that I did send my standard, what I refer to as victim letter to Ms. Powell, asking her to contact me about the case back on October the 16th of 2025.
Thank you, Mr. Coleman. Any other issues with regard to the pre-sentence report?
No, Your Honor.
Any reason not to go forward with sentencing at this time?
No, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And including the regular rules and conditions, part of yours are going to be that you are required to be on the mental health caseload and to participate in mental talk services. That's meant to help you be successful on probation and everything else. So obviously it's something you should be doing, but now it's something that's court ordered. So you've got to make sure and do everything that they ask you to do, as well as all of the other conditions. You're also not allowed to have any unsupervised contact with any child under the age of 18, and to have no contact at all with the victim or the victim's mother, Ms. Powell, in this case. So that means no contact, obviously in person, but it also means any other way through social media or phone calls or emails or text messages or anything like that. You understand? If you do everything you're supposed to on this probation, then this is an excellent opportunity because you will not have a felony conviction on your record. And at the end of the probation, the case will actually be dismissed if you're successful. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes, ma'am.
Also, there will be ordered $472.26 in restitution as part of this case, and you're not allowed to work anywhere in child care or daycare facilities, even private. Okay, so you can't do private babysitting or anything like that. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Oh, I received a note that you refused to take a drug test.
Yes, ma'am, because I leaned against the thing. I just finished sneezing back there and I felt like I was being singled out. I know I have alcohol in my system
So
from the
here's,
night before.
so let me explain. If you don't test
Mhm.
and let me see what is or is not in your system, then I'm going to assume that you're positive,
Okay,
and I will raise your bond for sure, and you'll go to jail.
okay.
So do you want to take the test and let me see what's in your system?
I don't have anything in my system besides alcohol.
Then go take the test.
I can't pee.
We're gonna give you some water.
I just had water.
Then you want me to go ahead and send you to jail?
I don't know. You haven't even finished running down my charges to me.
What?
Running down my charges to me.
What do you mean?
What I was here for, or if I'm gonna get a lawyer, and all that.
First things first is I'm ordering you to take a drug test. If you refuse the drug test, then you're refusing a court order, and I'll raise your bond and you'll go to jail. Then you'll have an attorney come visit you in jail and they'll go over all of the charges. If you want to take
So
your
I can
time,
bond out,
yeah, your bond's going to be raised though.
but could I bond out today? That's what I'm asking, because I
You
have,
don't know what I'm going to set your bond at
because I'm
yet.
trying to go to
You're-
work.
Well, then you should probably take the drug test.
Let's try.
Because the more you refuse to do it, the more concern I have, and probably the higher your bond's going to be.
I'm just worried about getting back to my kids and going back to work because
Then take the drug test. So either there's something in your system other
I
than
have
alcohol.
something in my system. I
Right.
said that.
You said you have alcohol.
Yes, ma'am.
I'm not worried about that right now.
Maybe some weed.
Take the test. Let me see what's in your
It's
system.
weed.
Okay. I want to see what's in it. Take the test. And then we'll decide. Just because you test positive does not necessarily mean that I'm going to raise your bond, but we're going to have some discussions depending on what's in your system. So if you want any opportunity today to walk out that door instead of that door, go take the test. Otherwise, I'm raising your bond right now.
I can sit and see if I can pee.
Go try.
Restitution.
I read about, I went to the DA already and did all that stuff. When I tried to pay, when I went last year and tried to pay this off. I've got the email that I sent. to them. Okay. Okay.
You wouldn't do it paid over on time.
No, not now. I did at the time.
That would have been all it is.
All right, this is cause number 23-41490, and ma'am, you're Shannon Stott.
Yes, ma'am.
And Ms. Stott, we reset your case just so that you could go get the
Yes, ma'am.
fingerprints done and all that got taken care of, correct?
Yes, ma'am.
Any reason not to go forward with sentencing then?
No.
No,
So Ms. Stott, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to pay restitution in the amount of $5,627 and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record.
Yes, ma'am.
And if you successfully complete the probation, the case will be dismissed at the end. You'll never have a felony conviction.
Yes, ma'am.
The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am. I do not want.
It's also very important that you start making payments on that restitution immediately.
Yes, ma'am.
I want that paid something every single month.
Absolutely.
What can happen is you can go through this whole probation, do everything else correctly. And at the end, if you haven't paid the full amount and I make a finding that you could have paid it, you could still be revoked at the end and go to prison. Okay,
Absolutely.
it's very important.
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you when she's ready to go through your
Yes, ma'am.
paperwork. Good luck,
Thank you.
ma'am.
Thank you.
Anisha Leonard, sentencing.
Judge, we have to set this for a restitution hearing. We can't agree on the amounts.
Okay, y'all have witnesses on restitution?
We have to reset it to a hearing in the future.
Oh, you need to.
You need to, yes,
Y'all
ma'am.
do, there's not an
We're
agreement.
still pretty, I'm okay with that,
Yeah,
because I was still pretty far.
We're about $27,000 apart.
Okay.
That's a pretty big amount. So let's do this. What I'll do is reset the case. We'll find a day. And do y'all anticipate longer than an hour or so?
It's a stack of paper. I don't know if you can go through it all. I don't plan on testimony longer than an hour, Judge. Okay.
Okay,
If you-
we'll set it for a hearing. Ms. Leonard, stay in touch with Mr. Rojas so that you guys can make sure and go over the restitution issues. And then I will listen to evidence with regard to that and make a decision on restitution at that next board. Okay.
Thank you.
It sounds like we'll probably do it on a regular day, just at the end of docket 11. That arrest will be on your record still, not the case, but that means you're entitled to an expunction.
Okay.
So I know it's a frustrating thing.
Yeah,
It wasn't
it is.
you, but
Yeah.
it would obviously to be probably to your benefit to find a lawyer to help you get that expunged.
Right, okay,
Okay.
so I spoke to one, he said that he didn't like Jefferson County. So they gave me to somebody else,
Okay,
and apparently I'm supposed to call him if I needed one, he said to call him.
I think it would
I
be
mean,
to
cause I
your
spent
benefit.
$2,000 to get out that I didn't even have,
I
know.
understand, and I know that's very
I'm not even sure if I'm
frustrating.
gonna be able to get that back or not.
Not if it was to a bondsman.
It was to a
If you
bond.
paid a cash bond, it'd be different, but if you paid it to a bondsman, unfortunately, I don't think so. So what I'm gonna do, if you want to wait for just a few minutes, we can get you a copy of that dismissal, so you have it in your hand to take to whoever you talk to.
Yes, ma'am.
Have a seat, watch for the clerk. She'll call you up when I have that done. Good morning, sir. Are you John Martin?
Yes, ma'am.
And Mr. Martin is charged with injury to a child, elderly, or disabled individual and cause number 25 DCCR 0583. What is the announcement?
We were waiting for CPS records. I understand that the records were just delivered, but they have not been reviewed.
I was able to download them last week, Judge, that I got with Miss Adams from CPS Family Services. They had previously sent them to our old email handle for the county, and so they thought they had provided them, but they hadn't.
Usually I thought they sent those to
I
us.
usually thought they did send them to you. They gave me the originals and the redacted. I did not turn them over yet because I wanted to see the guidance on that. I have them all downloaded, but
They've always sent them to us and then we give you the redacted and I keep the original.
right.
So I would ask if you would maybe forward all that.
To you.
Forward the redacted to Mr. Burbank. You keep a redacted, send me the original, and if you'll send her maybe a return email that just asks why they did it that way. Because typically it comes to the court, so we have y'all sign off that you received it. But I'll just do a normal reset. Sounds like you'll get it later date probably, and then go call Mr. Burbank. Y'all visit before that next court date, and we'll give it an announcement. The
And
next.
I haven't opened the originals, Judge, other than to check the page number. to
Yeah.
make sure there was-
No, if you'll just send the original to me, I think, and I keep that, and then you guys both keep a redacted version.
Okay.
Okay, thank you.
I have the excuse.
Yes, sir. Thank you. Ms. DeLage, you've got Carly Davis.
Yes,
Good morning.
Good morning, how are you?
Good. How about you?
Good, sorry, I was in the other court the other.
Nope, you're good. Good morning. Are you Carly Davis? Speak up.
Yes, ma'am.
And Ms. Davis has two cases, 25 DCCR 1451 and 1452, both driving while intoxicated, third or more. And what is the announcement?
Judge, we're gonna ask for a trial setting.
All right, did you already do a plea bargain rejection?
I
No.
thought was there one before I came on? No?
I don't see one in this case at least. So I would ask that you do one with her this morning. As soon as you do that, I'll go through everything and then we'll get it set.
Okay, sounds good.
Okay, thanks. Good morning, you're Christopher Pickens?
Yes, ma'am.
And Mr. Pickens has two cases, cause numbers 24 DCCR 2275 and 24 DCCR 2276. Both cases are injury to a child, elderly, or disabled individual set for trial to begin with jury selection on the 23rd. And what is the announcement?
Judge, in this case, it looks like the mother with the children had moved out of state. They are not cooperating. The sister has quit answering their phone calls. If we can reset this to a status hearing and I'll issue a subpoena, I suspect we'll probably wind up having to dismiss it.
How long do you need? Just 30 days? So what we'll do is just reset this to just kind of a status to give the state time to send it subpoenas. If somebody shows up, we'll see what happens. If not, then it'll get taken care of on that day.
Thank you.
So make sure you're back on that day and we'll see what happens, okay?
Yes, ma'am.
All right, thank you.
Thank
Good morning. Why wouldn't you take that off when the bailiff asked you to earlier?
No, I had told, because I had this on, I didn't want to take it off.
I understand, but it's not appropriate and you have to do that and follow the rules. It's not
Yes.
just when you're standing in front of me, but when you walk into the courtroom, there's no head. You should have known better than to wear a bonnet to court in the first place,
Yes, ma'am.
right? This is felony court, not where you show up in a bonnet.
Yes, ma'am.
So. Why were you late this morning?
I had to bring I woke up late and I had to bring my kids to school, so but I had called up here and told them.
So how old are you, Miss Richard?
How old am I? 25.
25. So you're old enough to set an alarm and get up on time.
Yes, ma'am.
Okay, so getting up late is some excuse that my kids would have, not something that a grown lady that has her own kids would have.
Yes, ma'am.
You need to be here on time.
Yes, ma'am.
I'm going to recall that bond forfeiture. And let me get to your case real quick. This is your initial appearance in clause number 25, DCCR 1611. You're charged with theft of property with previous convictions from August 14th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
So what I'm going to do, Ms. Richard, is since you made bond, I expect you to at least try to hire a lawyer. So I'm going to reset your case about 30 days to give you some time to try to hire someone.
Yes, ma'am.
If you get someone hired before the next court date, then just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, so different payment plans. Bring me the names of the lawyers that you've talked to when you come back, so I know you're trying, and then we'll discuss your option.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, if you'll step in front of the clerk right here, she'll give you a reset notice. All right, ma'am, are you Isis Martin?
Yes, ma'am.
And why were you late?
I was waiting on my ride and I had to find my way up here. Just my first time being here.
Say it again.
I was waiting on my ride and I had to find my way up here. I didn't know what's up.
Okay, so it's very important that you get here on time next time.
Yes, ma'am.
I'm going to recall the bond forfeiture. And Ms. Martin, this is your initial appearance in clause number 25, DCCR 1827. You're charged with a second-degree felony offensive robbery from October 14th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right, so what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. From the side, I didn't see you. Good morning, sir. You're Justin Wallace. This is 24 DCCR 1590, and Mr. Wallace's case is set for trial on for the 23rd. And what is the announcement?
Ready to.
State's ready for trial.
All right, then what'll happen is
I'm
I
sorry,
will.
I'm sorry to interrupt. I think
Yeah.
there may be something that we need to address. Is this the one where I did the habitual, or am I thinking of another case?
No, you did on this one.
I did on this
Yeah,
one.
the note.
Notice of intent.
Well, yes, Judge. I found a 1997 federal conviction for possession of controlled substance, and I've added that to the previous felony conviction this defendant has from 2006, felony possession of a controlled substance case. I believe it makes him subject to being a habitual offender, and I filed a notice, Judge.
So it looks like when we did the initial plea bargain rejection, that Mr. Wallace was admonished with regard to first-degree felony punishment. Have you discussed with him the new possible?
In this emotional courtroom session, the judge balances compassion with accountability in a series of life-changing decisions. A young mother who completed parenting classes, cooperated with Child Protective Services, and followed every court order receives a rare second chance through deferred probation, giving her the opportunity to avoid becoming a convicted felon. But the courtroom atmosphere quickly shifts when another defendant hesitates to obey a direct court order to take a drug test. The judge delivers a firm